Closing briefs were just filed in the New York Attorney General civil fraud case. The New York Attorney General's office is asking for approximately $370 million in disgorgement damages against Donald Trump. In the case, Donald Trump's lawyers are saying that Trump should have to pay nothing. New York Attorney General Letitia James also calls for a lifetime ban of Donald Trump ever doing business again, a permanent injunction from Trump ever doing business again in the state of New York, as well as the controller of the Trump Organization, Jeff McConney, as well as Donald Trump's former chief financial officer. And McConney is actually the former chief operating officer, and the former chief financial officer, Alan Weisselberg, to be permanently enjoined, stopped from ever doing business again in the state of New York. The $370 million in damages being sought is a compilation of different categories and different buckets. Part of the bucket for about $168 million is derived from the fact that Deutsche Bank lost approximately $168 million on interest that they could have charged if they had an accurate assessment of Donald Trump's net worth. The next bucket of damages, $139 million, stems from the deal to transform the government-owned old post office into the Trump Organization hotel there. And also Trump Organization made approximately $60 million from the sale of a golf course in Ferry Point in the Bronx. And then a $2.5 million disgorgement of severance payments that were made to Jeff McConney, as well as to Alan Weisselberg, chief financial officer and former chief operating officer there. You total that up, and that's how you get to the $370 million amount. In addition, for requesting a permanent injunction to stop Donald Trump, McConney, Weisselberg from ever doing business in New York again, New York Attorney General Letitia James is also requesting a 5-year injunction to stop Eric Trump and Don Jr. from ever doing business in the state of New York for those 5 years. In this closing brief, New York Attorney General Letitia James also requests that a financial monitor be provided to oversee both the dissolution of the Trump Organization as called for in the original order by Judge Engoron dissolving the Trump organizations, but also to ensure that all of these payments are timely made and to enforce the injunction of banning the Trumps from being in business in New York, and the need for a kind of permanent financial monitor for the Trump Organization on the Trump Organization, and the Trump Organization would have to pay for it. Here's the accusation to go all the way to paragraph 420 in this brief. It was a long brief, over 100 pages, by New York Attorney General Letitia James. And here's what is stated. Trump and the Trump Organization has proven itself profoundly unreliable and intransigent, continuing to prepare fraudulent statement of financial conditions, even while under investigation by the New York Attorney General's office, even during the existing monitorship. And you'll recall a financial monitor was placed on the Trump Organization after an injunction was issued by Judge Engoron back in October of 2022. Even during the existing monitorship that exists right now, defendants, the Trump Organization, Don Jr., Eric Trump, etc., have proven they are still not capable of adhering to the court orders. So $370 million being sought there. And let's not forget as well that Judge Engoron has previously ruled before the trial started in granting summary judgment in favor of New York Attorney General Letitia James that the Trump Organization will be shut down will be dissolved. So you already have that order, which is temporarily stayed while we are now dealing with the trial on the remaining causes of action. The remaining causes of action deal with not the dissolution, because that's already been ordered, deals with the money, which is disgorgement damages, recovering the ill-gotten gains by Donald Trump and Don Jr. and Eric and the Trump organization. That monetary amount being sought here is $370 million in this closing brief. And then additional causes of action for permanent injunctions and other injunctions against Donald Trump and the kids, the adult children, Eric and Don Jr. from doing business in New York, as well as McConney and Weisselberg and Trump, the permanent injunction for ever doing business, and Eric and Don Jr. for that 5-year period right there. Now, what is the Trump organization arguing in their closing briefs? I'm going to get into a little more detail in these briefs, but I want to give you, that's the argument by New York Attorney General Letitia James. Cold turkey may be great on sandwiches, but there's a better way to break your bad habits. We're not talking about some weird mind voodoo thing from your crazy neighbor. We're talking about our sponsor, Fume, and they look at the problem in a different way. Not everything in a bad habit is wrong, so instead of drastic, uncomfortable change, why not just remove the bad from your habit? Fume is an innovative, award-winning flavored air device that does just that. Instead of vapor, Fume uses flavored air. Instead of electronics, Fume is completely natural. And instead of harmful chemicals, Fume uses delicious flavors. You get it. Instead of bad, Fume is good. It's a habit you're free to enjoy and makes replacing your bad habit easy. Your Fume comes with an adjustable airflow dial and is designed with movable parts and magnets for fidgeting, giving your fingers a lot to do, which is helpful for de-stressing and anxiety while breaking your habit. The first time I tried Fume, it was way more flavorful than even I thought, and it feels very, very fresh. The look and feel of Fume is very sleek, it's well weighted, perfectly balanced, and extremely fun to fidget with. You gotta try the new Solano Fume. It's made with premium walnut barrel and onyx-coated mouthpiece that has a slightly softer finish. It's awesome. Habit by going to tryfume.com/Meidas and getting the Journey Pack today. Fume is giving listeners of this show 10% off when you use our code Meidas, M-E-I-D-A-S, to help make starting the good habit that much easier. So start the good habit at tryfum.com/Meidas, M-E-I-D-A-S, and save 10% off the Journey Pack today. Now going to what Trump's lawyers are arguing. They basically argue that there are different valuation methodologies for and methodologies and valuations are always subjective. They argue the statute of limitations, although I think that New York Attorney General Letitia James certainly could have asked for a lot more money, to the tune of, I think, over $1 billion. But I think New York Attorney General Letitia James' brief, as I read it, is actually a very conservative and low estimate of what the damages are. I think specifically to deal with any potential statute of limitations appeals. That's why I think it's only $370 million. So very intelligently, New York Attorney General Letitia James, I think, anticipated where Trump was going to go with the statute of limitations argument. I mean, Trump's been saying it all along, but she's made it basically, I think, statute of limitations proof, $370 million, make it non-appealable. I think that was her strategy there. So a lot of this is kind of Trump's brief is devoted to things that are now kind of a little bit moot and that don't apply. And one of the things that Trump argues for statute of limitations also, which will be rejected by the judge, Trump's been arguing that the closing date of a property is what should start the time for when the statute of limitations commences. And if you're going to calculate when the statute of limitation ends, start with the closing date of the transaction. And that doesn't make any sense at all, because that means that if you continue to use a property that you closed on many, many, many years ago that's outside the statute of limitations, but you commit fraud right now, that you would be allowed to commit fraud forever. by using fraudulent documents that were created after the statute of limitations has passed. So that just simply doesn't make a lot of sense at all, and that will be rejected. And then the argument from Trump's lawyers over and over again is that there's different valuation methodologies. And so here's what Trump argues. Disagreements among appraisals does not necessarily indicate that one valuation is inaccurate, and it's very common to have appraisers and non-appraisers disagree about the value of real property. This is so because appraisal is an art, not a science. Two equally qualified appraisers could appraise the same property at the same moment in time based on the same data at different values, because one appraiser may give more weight to some subjective factors the other appraiser might give less weight to. Appraisers exercise judgment in determining property value, choosing capitalization at discount rates, which were both used in determining various property values in the statement of financial conditions and the appraisals discussed in trial, are a pure example of subjectivity. Donald Trump is citing his expert testimony that was given at the trial. Valuation professionals regularly encounter disparate values for the same property, including differences in values in the hundreds of millions of dollars. In situations like that, a valuation is not surprised by the disparate figures because the professional must determine what subjectivities each appraiser relied on. Now, I'm going to say something that may be controversial here, but you'll see in a moment that it's not. What Donald Trump is saying there, in theory, I agree with, that appraisals could be subjective. There could be different valuation methodologies that different appraisal groups use, so I understand that. And by the way, Justice Engoron, who's presiding over the case, understands that as well. The issue in this case is not the subjective valuation methodologies. The issue is the inputs, the data. Like when you have the Excel spreadsheet, what is the data that you are putting in? Now, on Excel spreadsheets that you may have different formulas, right, that you put in, and it may spit out different numbers. What Trump is arguing is that having different formulas that are used by different appraisals on their Excel spreadsheets, I'm oversimplifying it here, that's not fraud. That's just the way valuations happen. And by the way, I don't disagree with it. But the issue becomes what happens when you input data into the sheet to begin with to run through the valuations of methodology that is fraudulent. So, for example, when you say that the valuation of your property at Mar-a-Lago is based on the fact that it is a residential property with no encumbrances on it. So you put in 300 million, or you put in the data set of what is the numbers based on the fact that it's residential property. Here are the comps of residential properties, but then you don't disclose it's not a residential property, that it is a commercial property, that you've executed a deed to pay less property taxes. You've intentionally devalued that property. You've previously signed paperwork stating that that property is valued at $27 million so that you could pay less property taxes on it. It is a club where you take membership fees. You can't sell it as a residential property based on the deeds that were executed. So the data of that is the fraud. By the way, I've said I think Mar-a-Lago probably has a valuation of $250 to $300 million if it were a residential property, because that's what the comps are in that area. It's a valuable property. It's not $1.5 billion like Donald Trump says it is, but I concede it is a very valuable property. It's in a beautiful area. It's by the water, all of those factors. So stipulated, not $1.5 billion. But Donald Trump devalued it. Judge Engoron was not saying that the property of Mar-a-Lago is $27 million. Judge Engoron is saying, you, Donald Trump, said it was $27 million, that it's a club, and that you forever intend to use it as a commercial property to pay less taxes. You go through all of Donald Trump's other properties, again, the data inputs is what is the fraudulent piece of information here, not the valuation methodology. So when you say that your penthouse is 30,000 square feet, but it's actually 10,000 square feet, that is fraud. Because you're now claiming that at 30,000 square feet, what's the price per square footage? You run your valuation formula, but it's 10,000 square feet. So 10,000 should have been the input there. Also, Donald Trump would run the same scam on, all of his other properties. He would say a certain building has full occupancy, is fully leased at the highest possible, lease rate per square footage in Manhattan, when in fact it was not fully leased and it's rent controlled. So you can't possibly get the higher valuation when you put in fraudulent inputs. Now, I could do this on each and every property, but you get the point here. And that's what the judge has said. This isn't a case about subjective valuations. This is a case about the input data being fraudulent and then trying to reverse engineer the financials with different sets of books to basically try to justify these fraudulent numbers that Donald Trump would come out with from the outset based on fraudulent assumptions. So that's what you have there, and just one of the kind of just egregious things that I think Trump argues is that in this brief is errors or misstatements happen all the time in accounting. If there are no indicia of fraud, such as concealment, forgery, or deceit, then there is no basis to determine that these statements of financial conditions are fraudulent, and any misstatements are just accidental errors. So the way Trump deals with everything that I just said to you was that anytime there's outright fraud, Trump calls them accidental errors. That's what he's saying with these things, accidental errors, and obviously they're not. So just going through this New York Attorney General brief, just again, very briefly, I think it's succinct. I think it's well done. I think it's conservative on the money amount. I think they could have asked for more right here. And a list, it's like 111 pages, and it goes through in painstaking detail all of the testimony that was given, and basically says, look, on a voluminous summary judgment record, this court has found that Donald Trump and his company and its top executives, Eric and Don Jr., were liable for persistent and repeated fraud under the New York executive law in preparing and certifying as true Trump's falsely inflated statements of financial conditions. The court found that between 2014 and 2021, why is that period relevant for the statute of limitations? Defendants overvalued the assets between $812 million and $2.2 billion. At amounts that are material by any standard. The court left for trial the remaining causes of action alleging illegality under the law by falsifying business records and financial statements, committing insurance fraud, and conspiracy to commit those acts. Based on the documents and testimony introduced during 44 days of trial, the people have established that defendants committed the alleged illegal acts with the requisite intent to defraud when they employed numerous deceptive schemes to falsely inflate more than a dozen assets on statement of financial conditions for over 11 years, reaped hundreds of millions of dollars in ill-gotten gains, and continued to conduct business without meaningful corporate oversight to prevent further fraud on the marketplace. And it goes on to say that defendants have reaped hundreds of millions of dollars in ill-gotten gains. The acts of corporate malfeasance warrant appointing an independent monitor also to closely oversee the company for at least the next 5 years and to impose a statewide permanent injunction barring Trump, Weisselberg, and McConney, and 5-year bars on Eric Trump and Don Jr. So what happens next? Oral argument, closing argument will take place next week. And we will see after there. We'll have a ruling by the judge. But things are moving quickly, and briefs have been filed. So there you have it. I'm Ben Meiselas. This is the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers thanks to your support. Have a great day.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.